morning and welcome to the latest edition of Mozilla Mornings. This is Mozilla Mornings Light. It's every bit as good as the other content, just no pastries and no coffee that we're providing. So thanks for joining us. We appreciate the time you've taken. I'm Brian Maguire. I'm a journalist based here in Brussels. I'll lead the session this morning. And today our focus is on the Digital Services Act, a risk-based approach, specifically the draft law's provision on risk assessment, risk mitigation, and auditing for very large online platforms. We'll be looking at what these provisions seek to do, how they might work in real life, and what we can learn from related proposals in other jurisdictions as well. And just to say to our audience before I introduce the panel is that we really want your participation today. You can send questions and comments as well for our panel in the Q&A section there. Our team will highlight some of those for me to bring through. We'll try and get through as many of those as possible. Please tell us who you are and where you're from, if you don't mind. And if you have a specific question for any of the panelists, please identify that in your comment or question as well. So our speakers today, Carly Kind, she's the director at the Lovelace Institute. Good morning, Carly. And Carly is a human rights lawyer and leading authority on the intersection of technology policy and human rights. We also have Ben Scott. He's the executive director at Reset, an initiative focused on tackling digital threats to democracy, growth industry. And Owen Bennett, he's the senior policy manager at the Mozilla Corporation, an expert in policy and law surrounding European content responsibility and platform regulation. So good morning and welcome to all of you. Just before we get into the discussion, I'll ask our panel just to give us a 60-second elevator pitch, their key message or their headline for today. Carly, can we kick off with you?
Great question. My first headline to the audience is that I'm no expert in the detail of the DSA, so please don't ask me any difficult questions. But I think the work that Ada Lovelace Institute has been doing is really more around audit as a mechanism for ensuring ethics and accountability in the space of content moderation and algorithms more broadly. And so we're looking at what does the emerging field of auditing look like? What types of technical capabilities do we need to make it possible? What type of legal and normative rules do we need to make it effective? So I suppose my major message will be we're in the midst of a really interesting development around audit. There's a field emerging, a set of practices emerging, and the DSA will be really key in shaping that.
Thank you. Ben, good morning.
Good morning. I'm going to step up one level and say, my headline message is that I've spent the last couple of years running around the world talking to governments that are focused on different aspects of digital threats to democracy, who are developing different kinds of policy solutions to illegal content, to recommender systems that lend themselves to polarization and radicalization and extreme views that are looking to uncover ways to mitigate these harms. The DSA is the first major statute that understood audit as an essential component, that without audit capability, without the capacity in the regulatory authority to open the black box of how automated systems curate organic and paid content on these platforms, you cannot really regulate them effectively, nor can you verify whether your regulations are being complied with. So to me, the DSA is groundbreaking for that reason alone, although there are many other reasons why I think the DSA is an important piece of policy. This the centrality of the audit provision in the DSA and its clear linkage to the other regulatory provisions that are established in the proposed law really signals to me that its drafters have understood an essential problem with platform regulation in general, and hopefully that will become a pattern that others will follow.
Excellent. Thank you. Good morning, Owen.
Good morning. So I'm going to go one level above again in terms of higher order. And I think that as an opening gambit, I think that we can be quite happy with where we are in terms of the DSA draft law. Like I recall being on one of these panels around this time last year and then saying that the DSA was going to be the Commission's last chance saloon. It was like the last chance that they had to really get content regulation right, because there wasn't going to be another opportunity for probably several more years. And if you had told me then that fast forward a year, we would be having this conversation about the merits and the opportunities of the DSA's risk-based approach, I would have been quite happy. And so I think that as a high level message, I think from a Mozilla point of view, we're really happy with the kind of the policy contours of this proposal, like where it seeks to go. And obviously there's a lot of things that need to be ironed out, need to be clarified, and hopefully conversations like this are a way of kind of moving in that direction and getting towards a really tight and workable legal regime.
Excellent, thank you. It's unusual, I have to say, as a journalist and moderator, to hear such high praise for the Commission on a policy document so early in its life. But let's go off, Ben. I just to set some of the territory here, and you've already touched on some of this already. You know, what kind of risks are we trying to address with the DSA, and do the definitions go far enough?
I think that's the question everyone's wrestling with. Is you can establish all the powers in the world, and if those powers only apply to specific aspects of the product or service you're trying to regulate, and you miss the target with your definitions, it's all for nothing. And so, you know, I think there's a lot of scrutiny of spots in the proposed law, particularly Article 26, which lays out the kinds of harms that the law contemplates being subject to this risk mitigation approach, and to the audits that we all highlighted at the top of the call.
Can I just interrupt just a second, because I know half our audience is probably familiar with this and some won't. So just Article 26, it deals with dissemination of illegal content, negative effects on the exercise of fundamental rights, and intentional manipulation of the platform services as well, and the response that those platforms and services will have to make to deal with dissemination of illegal content. Just in a quick scope of what that's doing.
Remedial. I will confess that I brought it up on my screen and reread it before we started the call. But that to me is sort of the fulcrum of this proposed law, and the reason why it draws my attention is because it is the way that the European Commission has attempted to address a problem that is vexing regulators all over the world, particularly in democratic societies, who want to get at the problem of the platform without regulating speech that is not clearly illegal. That's the real problem with the platforms, is that there's one class of content captured in piece 1 of the definition you just read, illegal content. In every country, there are definitions in law of what constitutes illegal speech, and there's no reason why the illegal speech online should be treated differently than illegal speech offline. There's not a lot of controversy about whether that should be taken down from the platforms. The controversy is over the how and the transparency with which it is done. However, that illegal problem, in my view, gets way more attention than it deserves, because the vast majority of the problem that we all think about when we think about the problem of platforms and democracy is with not clearly illegal content, manifestly illegal content, I think is the term that the Commission uses, but with content that is not manifestly illegal. But nonetheless, when amplified by algorithmic promotion, distorts the public sphere and creates a harm for the public that is nonetheless a risk. And how do we deal with that risk? And how do we define the type of risk that we're dealing with? So as a regulator that does not want to infringe on freedom of expression, you can't say, here are the things that we're worried about that are not clearly illegal, but if amplified in unspecified ways by platform recommender systems that increase the frequency of this kind of content in people's news feeds or in their Twitter streams or in their search results in ways that are disproportionate from the way those views are actually held in the population, that constitutes a harm.
Okay, let me put this to Carly in a slightly different frame as well. We'll come back to this in a moment. Carly, just, I know I don't want to burden you too much with the detail of the DSA, but in general principles, this isn't a level playing field, because as Ben says, you know, what constitutes illegal content in one country is not the same in another. So there's no level playing field here, even within Europe. And if we're talking about a single market as well, you know, there's no open playing field as well. You know, in Spain, if you happen to be a rapper who strongly disapproves of the monarchy, you can end up in prison in a hurry. Hungary for disliking other elements of the government. You know, so how do we balance what the Commission's trying to do here with free speech, and can you really deal with this in a risk assessment way?
I think it's very, very challenging. I think that we've seen, even from the recent attempts of the Facebook Oversight Board to apply some kind of international set of human rights standards to content moderation decisions, there are real cultural specificities to some of the questions around freedom of expression. I think what the DSA here is trying to do is to establish, as far as is possible, a standardized framework. And in order to make that real, I think we could separate out some buckets of challenges. Some is really around specifying and understanding and having regulators understand the content of the harms that they're trying to address. And Ben spoke into that, but I think a second is really around standardizing the approaches for addressing those harms. So how do we make sure that there's kind of equality of arms when it comes to regulatory capacity to inspect these platforms? And, it may be that some European countries have regulators that have more technical capacity than others. How do we start to kind of build up and standardize across member states and the Commission the ability to kind of address these issues equally and with the same level of competency, I suppose, will actually be just as important as standardizing the content of the harms that they're trying to address. I think that's one of the big challenges that we're really focusing on at the moment.
Thank you. Owen, is this really a change in how we deal with tech policy, or are we dealing simply with buzzwords here, or is this the structure coming into place of something that will have real teeth?
I think it is quite a paradigm shift. And I think when you look at the way the European Commission communicated around this in the last year, there was very much a lot of rhetoric that the DSA was going to be a next generation approach to content regulation. And I think it largely is that. And I think the reason why is because it responds quite clearly to the kind of problems that Ben has outlined just a few moments ago. Because today, I agree, if you ask people what they're concerned about online, it's not very often illegal content. I think that we can be quite confident that the very large mainstream platforms and the tech industry in general today has been doing a relatively decent job with addressing illegal and particularly manifestly illegal content, because it has been something which has been around since the very early days of the internet. But obviously in the last couple of years, you've seen the emergence of new types of products, new types of business models, and this kind of endless stream of disruptive innovation. And so some of the harms that we see today are largely about how companies are interacting with the content on their services, and how new and interesting and novel product features can give rise to unforeseen or unmitigated risks. And so I think by looking through that lens, we give ourselves a much better schema for being able to respond to those problems without breaking the internet, without treating everybody like they're a very large platform, and without undermining fundamental rights. And I think this is a natural progression. We had the e-commerce framework for the last 20 years, and that was made at a time when the internet was very different. The types of systems we have today, like recommender systems and news feeds, they were simply unfathomable back then. And so the e-commerce directive was all about trying to protect a fledgling industry and trying to help it grow in a kind of a regulatory sandbox. And I think
competition law approach, basically.
Yeah, I think, and kind of sheltering a niche industry. And I think it's the very fact of the ECD being so successful is now that we're starting to see these new problems arise today. And so I think that we should be comfortable with the fact that regulation has to evolve with those problems too.
Okay. And when that regulation evolves, Ben, the DSA puts a lot of emphasis on national regulators as well. This is where the teeth will bite. That requires resources, it requires training, it requires a clarity of legal interpretation as well. Are you comfortable with how the DSA sets this out in terms of what the national regulators are required to do? Will it work in practice?
I think, like all things regulatory in the European Union, it'll be hit and miss. And it will take a while for there to be commonly understood standards about how these rules are applied. I think the Commission has no choice but to devolve the powers down to the member states and to leave up to the member states how the digital services coordinator will be designated, whether it will be a new regulator, a standalone institution embedded in another existing regulatory institution. Is that a data protection authority? Is that a broadcast authority? Is that a telecommunications authority? Those institutions are going to look different in every member state. And then you add on the complexity of, well, do I, as a regulator in any given member state, handle all of the problems affecting my citizens, or do those get transferred over to, let's be honest, to the Irish in a lot of cases where these companies are incorporated? Does that put an unbearable burden on the Irish regulator to handle everything to do with Google and Facebook? I think those are all fair questions to ask. I read the DSA as hedging against that to some degree by creating the board at the commission, by creating some additional capacity to support the digital services coordinators. How exactly that will look in practice and how it will work and what the level of coordination will be between Brussels and any given member state, and whether the member states would be willing to give up those big cases and hand them over to the Irish. Those are pretty big open questions in my mind.
Thank you. I want to come to Carly in a moment just to talk about how you audit big platforms as well. But first, Owen, what are the harms that we're trying to prevent here? What is the DSA trying to do? And you said no, some harms we can't know yet because the technology is evolving. So how do we define this?
Well, I think this kind of goes back a little bit to the earlier question over what are the definitions sufficient in the DSA. And I think when I've been looking at this kind of risk-based approach, I think it all comes back to, well, what is risk management? What are we trying to solve for there? And typically, if you look at other sectors where these methods are deployed, people think in terms of the probability of a bad outcome and the impact of that outcome when it arises. And so you're trying to minimize the risk of things going wrong, and you're trying to ensure that when those risks do invariably materialize, that the impact is not as bad as it would otherwise be if you had done nothing. And when I read the DSA, particularly the articles themselves around like risk and stuff, it seems very much that the Commission's focus is largely on trying to minimize the damage when a bad thing goes wrong. So for instance, if your service is weaponized for disinformation or for the dissemination of illegal content, you need to make sure you have measures in place to address that when it goes wrong. But I think that's good. It's a positive step forward to think in those terms, but I don't think it's really sufficient. Because if you look, for instance, to think of an analogy of a theme park. Theme park is a risky place. That's what makes it fun, because you're going there for the thrills. If you went on a roller coaster and the manager of the theme park simply told you, we take your safety very seriously, and we ensure that if the roller coaster crashes, that we can get you to a hospital straight away to minimize the damage it causes you. You would think, well, that's great, but also at the same time, you'd want to know that the theme park is taking steps to ensure the roller coasters are safe in the first place, that they're regularly checked, that they would conform to all the necessary safety standards. And so I think in the DSA, given that a lot of the kind of harms and the risks we're trying to solve for are risks that are related to how companies are acting, to the markets they roll out in, the systems they use, and the various other kind of contextual factors that comes with running very large, very influential businesses, I think that the risk-based approach needs to focus more on those choices. It needs to really invest in the bloodstream of a company and to make sure that when companies are operating, thinking prudently and thinking wisely and like moving slow and fixing things is very much part of the process, and not just an afterthought that you clean up.
Thank you. The only good thing about attraction parks is the food, Owen. I think we can all agree on that. And Carly, the platforms, how do we audit platforms? What's the model that we need to pursue here? And can we do this in-house? Do we need to bring in a whole bunch of consultants who can be expert in this and perhaps more commercially minded as well? How's this done?
So one thing that's come with the DSA, and also, and I'm not sure how familiar the audience is with this, but a similar and parallel piece of work that's happening in the UK around the online safety bill is a real maturing of the conversation around audit. I would say 2 years ago, people used audit to refer to any and all type of accountability mechanisms that might be executed vis-a-vis large platforms and social media companies. And we're starting to see some real granular detail come out in the DSA, in the online safety bill, and elsewhere. I think from the DSA's perspective, there's kind of 3 types of audits, or 3 kind of components of audit. There's a kind of a kind of monitoring function, which is about ongoing oversight by regulators to surface concerns or non-compliance with the DSA. Then there's specific investigations on specific instances of non-compliance. And then there's an annual compliance function, which would be a kind of annual audit. Now, each types of those functions require different technical and qualitative measures in order to really ensure compliance. And in terms of the detail of that, we're really seeing an evolving field, an evolving discourse about what would require, for example, to do ongoing monitoring. Is it about creation of documentation on the part of the platform that can later be inspected? Is it about permitting access or permitting interviews, permitting scrutiny of technical systems? And which parts of that can be outsourced to an external auditor versus conducted by a regulator itself? At a top level, I would say there's kind of 3 areas that would need to be looked at from an audit. One would be around policy. So what policies the platforms have with respect to the specific types of content under scrutiny, how the platform says it's going to act with respect to that, what criteria for intervention there are. And then a second one is around process. So what processes are actually followed by the platform. And that breaks out into 2 sections. One is around technical implementation and one is around kind of personnel implementation. How is the governance structure being executed? And then the third is around outcomes. What does the platform know about the outcomes of its products? What data do they collect? And to what extent can those outcomes be scrutinized? And I would say there's a range of different technical methods that can be pursued. To your point there about should there be an external audit industry, Brian, one of the ways, if we look at an analogous, by extension, analogous field, the financial sector, huge, complicated sector that has really struggled with ethical normative issues, particularly since 2008, and tried to embed those through a stronger audit regime. We have seen an industry pop up around external compliance that helps companies adhere to this. I suspect we will see the same here. But it should be acknowledged that that industry is in its infancy. And there was a really interesting article in the markup last week just about how much turmoil the audit industry is because there's no standardization, there's no common understanding about what audit is and how it has to be done. So I think the DSA will really force the crystallization of methods, approaches, best practice when it comes to audit. But it's going to be a little bit trial and error, I would say, until, and we'll see some kind of competing regimes emerging, I would say, in European countries, in the UK, and then in the US, where there are a number of pieces of legislation also calling for algorithm audits. And I suppose, hopefully, we'll see a coalescence around a highest common denominator when it comes to audit in the coming years.
And do you see certification of this audit process, or is this just an oversight which would have some recommendations, or would this be punishable as well? How should this go?
Again, I would say there are layers. I suspect we'll see a certification industry pop up the same way we've seen in data protection. And from a data protection perspective, that's been quite problematic because data protection certification is something that has, come up from a grassroots level. It isn't standardized, isn't necessarily quality checked by some central authority. And I think we'll probably see a phase of audit where there's, audit approved by a XYZ external auditor that doesn't necessarily correspond to the requirements of the DSA. I think given the immensity of the task and this uncertainty about regulatory capacity and who's going to implement, I think we'll see a mix of regulators doing specific compliance related audits, specific compliance related investigations, and then companies trying to hedge their bets or preempt any critique through preemptory audits that will probably be serviced by an external industry. And we're seeing that a little bit in the US at the moment with companies voluntarily undertaking audits in order to kind of preempt any regulatory scrutiny. I'd say it'll be a mixed bag unless and until we get proper coverage of regulatory capacity across member states, then I think that that's probably a long way out.
Yeah, I was just about to say that this doesn't sound like it's going to happen anytime soon in real terms. Thank you. Ben, auditing requires that you see inside the black box. Does the DSA do anything to help us see inside the black box?
I think that the powers established in the DSA are sufficient to open the black box. What remains to be seen is if any regulator will choose to use those powers. I can make a case that the GDPR is a great idea and a wonderful piece of statute, and someone should really try it. There are many pieces of the GDPR that have never been fully enforced. And the reason isn't because it isn't written in plain language in the law. It's because no regulator has picked up its tools and gone in and tried to enforce those aspects.
But
So
you
the
got to
same
know how to
would be-
use the tools, though. Do you think this is a problem of education, of training? What's the issue here?
I think it's resources and political will, which is why.
Does the DSA provide any way in which the European Union will fund training, fund the resources needed to do this?
Not that I see directly.
Yeah. So we end up with Ireland, as Carly said, having to deal with a lot of this, perhaps, and other countries who simply don't have the resources to do it become an easy option.
Were I a member of the European Parliament, these are the kinds of questions that I would be raising and seeking to solve as this law makes its way through the process. That it's not enough to have the right language written on paper in the law. It requires having the instrumentation correct, and that means having regulators with both the education and the resources and the political will and the motivation to go ahead and enforce those laws. We've been for the last half hour talking about all the ways in which this is going to be very hard and complicated and messy, and I want to put a little bit of a silver lining here, which is, in my experience now watching technology and telecommunications and media regulation for the last 20 years, it isn't necessary for the law to be perfect or to be perfectly implemented in order to see change in product and practice in the market, because companies will begin to assess regulatory overhang and to begin internalizing some of the costs that they have been externalizing up to now, because the lawyers in their offices will say, look, there's a non-zero chance that you could be held in non-compliance, and the penalties for non-compliance are extraordinary, and the potential brand damage for being held in non-compliance with such an important law, especially if the politics and public opinion about these issues are aligned against you, that we'd better go ahead and start changing product and practice. You saw that with the GDPR. Despite the fact that the GDPR, in my opinion, has not been effectively enforced, it has changed industry practice very substantially. And I think the same will be true for the DSA, even in advance of any adjudications being brought. So an imperfect law is therefore better than a perfect one in any case, because it begins to change the assumptions and the expectations in industry. And in that way, I think we'll begin to see movement, particularly amongst the very large platforms who are obviously at the center of this proposal.
Can I just reinforce what Ben's...
Alina,
sorry,
yes, go ahead.
I was just going to say, to reinforce what Ben said, I think even if regulators didn't get to the stage of executing audits and things stayed at a self-commissioned audit stage, or even just at a documentation of due diligence process, we would be miles ahead of where we are now. So I think putting that regime in place, even to the extent that it incentivizes documentation, which not only creates evidence but also changes practice. We can see, things like model cards being used does actually change the practice of developing technology. So I think, I certainly don't want to give the impression that it's all critique either. I think that Ben's point is right. It's an immense step forward just to require platforms to undertake this type of due diligence.
Thank you. I was just going to say, Alina Popescu sent us a question. I'm asking about who should audit the platforms. I think that's been answered, Alina. If we didn't answer that correctly for you, let me know. We also have another question just following up on, it's from Vesna, following up on Ben's GDPR case. What's with the right to explanation? Do we know if and how that law has ever been exercised? Ben?
Sorry, I don't think I quite understood the question. Can you restate it?
Sure. I think you can see it in the Q&A panel as well there. Picking up on your GDPR case reference, what's up with the right to explanation? Do we know if and how the law has ever been exercised? So I think you answered this actually, pretty broad.
Good question. I don't know that I have a great answer to that question. Owen is much more of a GDPR hand than I am. Owen, what do you think about that?
Owen.
I actually was going to say I'm not. I think that maybe we'd all need to consult with our friends in the data protection community to answer that question. But I do, just to pick up on the other question that was raised by Alina regarding auditing. I think building on what Carly says, the idea that we're going to have a kind of cottage industry for auditing a peer and other forms, I think that's going to be crucial. It's going to be crucial to solve the problem that Ben has identified, that this might be great in theory, but kind of useless in practice. And the reason being is that the more kind of polycentric regulation is, the lesser the chance you have of kind of choke points or failures. Because, like, for instance, we see in GDPR, there's so much pressure is put on one member state to actually enforce, meaning that if there's a problem in that member state for whatever reason, then the law can effectively become useless for many people to enforce their rights. So I think in addition to having the idea of these third-party external audits, assuming we can get that standardized to a degree, and in assuming that we can ensure that there's a structural misalignment of incentives between the auditor and the audited, that's obviously essential for that misalignment to be there. I think it'll be a really big step forward. But I also think that a kind of a third pillar of this is there needs to be systemic transparency, that's systemic in a public facing way into how platforms are working and how some of these risk mitigation efforts are being made. Because even though risk management is a very kind of technical subject and it's considered to be a science, I think it's fair to say all science is value laden to an extent, and we are making value judgments in what we choose to assess, how we assess it, and how ultimately we choose to act upon it. And personally, I don't want that value judgment to be made just within companies and just within engineering communities based in Silicon Valley. I want to make sure that everybody has a chance to be part of that process, see what decisions are being made, and ultimately correct for those decisions when they're wrong. So the DSA does make some useful ventures in this regard by, for instance, facilitating access to data for researchers. I think those are provisions we need to spend a lot more time working on, because they need to be as broad as possible, and they need to be ensured that it's not just trusted researchers or vetted civil society orgs, but really as many stakeholders as possible have a chance to be involved in this kind of auditing, this risk mitigation process to ensure that it works for everybody.
Thank you. I wrote a piece on Sunday about this in the context of AI and ethics as well. The Commission's AI ethics guidelines, the guidelines are good, they're sensible. But one of the points I made was that basically we should start with values. We should encode the values in a constitutional way. And I wonder if the same doesn't apply here as well. What is it, like you say, what are we trying to do? And we can't leave the value judgments to individual companies or other organizations or even national governments to do this if we want a harmonized approach. Carly, question for you. This is from Eliska Perkova. Thanks, Eliska. She's from Access Now. I would like to ask about the role of mandatory human rights impact assessment. Do you think the HRIA should be the primary mechanism for assessing systemic risks, followed by a risk-based approach as a secondary mechanism?
That's a great question. Yeah, I think that human rights impact assessment provide absolutely the platform, the kind of template and starting point for risk assessment in this space. As to whether it's, I would say it's necessary, perhaps not sufficient to capture all of the values questions that you just alluded to, Brian. So I think absolutely as a floor, we should be requiring mandatory human rights assessments. Whether or not it will enable us to capture some of the larger ethical questions that aren't captured by the detail of human rights impact assessment, I'm not entirely sure. I think one of the things we've struggled with in the AI ethics space is where articulating very high level principles without really getting into the details of how they apply in practice and how they involve values judgments which needed to be traded off against each other, and applying something like a principle like justice, for example, or fairness, is very difficult to judge. And I think including that level of analysis in a risk assessment is more or less ineffectual. Equally, I think human rights impact assessments provide a floor, but perhaps don't allow us to get to that level of detail around trade-offs around justice, fairness, structural questions, for example. So certainly the model, yes. Whether or not we need some type of additional layer of consideration, I would say we also need to think about form and function. So I think I think Owen was getting at this point, when risk assessment is done by a company, we're going to get one particular perspective on the world. When it's done, for example, in a participatory way, which involves affected users, we might get a different set of insights. So to go back to Owen's example of the roller coaster in a theme park, you could do a whole set of risk assessments, but not necessarily think about people who are above 7 feet tall. And when they go on the roller coaster, they have a whole different experience. So do we know that all affected communities are involved in weighing into risks and how they perceive them? And I think that involves rethinking a little bit the form and function of impact assessment to try to move towards something like a participatory or community-based impact assessment process as well.
And also just in terms of how sorry, go ahead. Go on.
I just wanted to quickly add to that, because I think it's super relevant in our context. If you look at other sectors where risk is a key focus, take for instance the general insurance sector for, say, car insurance. We have like almost 100 years of data about how cars get involved in accidents, and we know pretty well the various kind of contours of what those risks might look like. With technology and with content sharing platforms and other services, we are dealing with innovation that's moving so quickly, with new product features that are being rolled out in different ways all the time, that it's effectively impossible to make a long list of all the risks that might be faced. And so while, like as Carly says, we should set up kind of procedural standards and principles by which this should be assessed, it's never going to be possible to identify all of the risks in a generalized format. And it's never going to be possible for one entity in one place and time to adequately define them all. And so that's why in our sector, more than any other, is going to be incredibly important that this is transparent, public facing, and indeed participatory for affected stakeholders.
Thank you. Let's talk about advertising transparency provisions in DSA. Ben, what's your perception? Is the detail there?
I think it's simple and sweeping in the way that it describes the transparency requirements. I think it will have to be customized on a platform by platform basis, because the way the ad platforms work is different for different services. I think provided that there's flexibility to evolve the rules over time to match the development of advertising in this industry, I think the transparency provisions are in principle correct. So I'm pretty happy with the way that they've addressed that issue, but I think it's something that is going to constantly change, and regulators are going to have to keep on top of it, particularly if we find systematic evasion of rules in order to perpetrate more deceptive advertising practices through loopholes. We've got to be able to rapidly address those.
What are the chances of that, really?
Who could imagine it?
Owen, what's your take on this?
Well, so we worked very hard on the ad transparency piece, like along with many allies in the community, and I think that we were pretty happy. Like we kind of share Ben's sentiment. It's a clear and it's a crisp framework for ad transparency. We actually dedicated quite a few Mozilla mornings to kind of teasing out what that might look like. So I think that's one of the areas where now we're thinking this is a pretty good piece of the puzzle. Let's see how we can maintain it and possibly strengthen it. So like as Ben says, it is more future proof going forward. But I think the ad transparency piece is a really good example of where like transparency is not going to be an end in itself. Like this is not going to solve the problem of disinformation or amplification of harmful content on certain platforms, but it is a necessary prerequisite in the way that auditing in the more broader sense of the risk-based approach is also probably not going to be an end in itself, but it is going to give us the tools and the insight by which we can address the kind of much more trickier problem of how do we correct for certain problems in the tech sector, and how do we sanction certain problems if they are systemic. So yeah, a good start, but definitely not to be confused with the end of the line.
Thank you. Carly, a question from Averna McGowan. Averna, good to see you online. I'm not going to read your whole dissertation here, just the top question. The same human rights offline need to be enforceable online. What do the panelists think about the implications for the rule of law in the DSA? Carly, first.
Big question. I don't know if I have a clear answer to that, other than to underscore that the DSA takes us a long way forward in recognizing that we need human rights aren't going to be protected online inherently, but actually require enforcement structures, regulatory structures. And I think for a long time, there's been some reticence around regulating the online space. And that in part links to the origins of the internet as a unregulated and fully democratized space that not under the control of any government. I think the DSA takes us a long way away from that original vision, but by necessity, and I think closer to providing some sense of the rule of law online. So, you know, from that perspective, I think the DSA is a huge step forward, even with all of the caveats that we've expressed here today.
Thank you, Ben.
Well, I think as the question implies, in practice, this law, like any law you might write to govern the flow of information and content on a platform the size of these, people will take advantage of the laws to seek their own ends as government actors. And that's going to be true in the European Union, it's going to be true around the world. I think to some degree that is inevitable. We can hedge against it as best we can. We can write qualifications, you can add language into the addenda to the law explaining what you mean. Areas be exploited. There's one aspect of it, however, which I want to highlight, which I think we haven't gotten to, which I think is very important, and that is the degree to which the DSA will be precedential. I can tell you, working in many capitals around the world, how closely this document has been scrutinized by other governments, by civil servants and ministries and regulatory agencies around the world, because it is the first of its kind to take on these big questions like audit and risk mitigation, to deal with not manifestly illegal, but clearly harmful behavior on the platforms. The downside of dealing with companies that are the largest and wealthiest in the history of the world is that they're very difficult to regulate. The upside is that they're everywhere. And that means any country that implements any kind of rule that looks a little bit like the DSA after the DSA is in place, any regulatory oversight of audit, any independent third-party assessment of data that's put in a repository, in a data sharing agreement similar to what the DSA proposes, those all have the opportunity to turn up areas of problematic behavior of a technology that's come off the rails and produced a harm that government needs to address. And when we see it anywhere, we ought to be able to address it everywhere. And in that way, there's a kind of government crowdsourcing that can occur when we're dealing with the same products and services that are applied in very similar ways in countries all over the world. No regulator will be able to address all the problems with an audit regime. There simply won't be the competence and the scale of implementation. But we don't necessarily need that if we can all be in a community of practice where we're sharing information about what was found, how it was investigated, how it was adjudicated, and what the response from the company was. Because if you get a positive outcome one time and the company sinks the cost to change that product or service in order for that country to be satisfied with compliance, they've already spent the money in order to fix that problem, and the additional cost to deploy the same solution in other countries ought to be marginal. That should be an advantage for us going forward if we can figure out a way to make this an international community of regulatory dialogue.
If I could just come in, Brian, on going back a bit to Verna's question about the fundamental rights risks for free expression, particularly from the DSA. And I share her sentiment. I think there is a lot of risks there in any regulation that's governing online speech. However, one kind of comfort I draw from reading the draft text is that I think there's a pretty strong way and there's a pretty clear way of implementing the DSA which doesn't fall foul of some of those problems. And this is in contrast with, say, for instance, in the last EU political mandate, where we had the copyright directive and we had the terrorist content regulation, where both of those files were really aimed at trying to get as much content off the web as quickly as possible and leaving the adjudication as to whether that content was illegal or harmful or public interest to after the fact, and if it was even going to be made at all. Whereas I think with the DSA, by shifting the focus away from content per se and really onto the question of what does kind of higher order responsibility look like from platforms? What are the kind of process they should have in place? What are the kind of procedures they should have in place? Then there's a way of doing this which is a little bit less rights interfering, because it shifts the incentive. It shifts the incentives more towards the companies themselves and less onto regulating the speech and regulating the behavior of those who are using their services. I think we lost Brian for a second.
We lost Brian. Maybe we should.
No, back.
Back.
Zoom crashed, guys. Sorry, big online platform. We're back. So thank you for that, Ben. Carly, on this as well, I don't want to push you too much on the advertising side, but on disinformation in terms of how the DSA would be perceived in the UK, how the UK perceived it, what lessons can be translated here as well?
I think that the UK's regime, UK is pursuing its own regime around online safety. There's a lot of similarities in terms of the mechanisms for audit and accountability. I think there'll be quite a lot of skills sharing, knowledge sharing, I would hope to see in the coming days. The UK is taking a slightly different framing around the duty of care versus the DSA's approach. But I think, you know, at a top level, I would say the two jurisdictions are moving in a similar direction. And, you know, I'm sure we could be nitpicking the differences between the two, but I'm not sure that's particularly useful, because I think the overriding message is, to Ben's point, we're moving in a direction that's going to have the effect of having much more accountability on platforms and preventing the kind of whack-a-mole problem where platforms could seek other jurisdictions to kind of take safe harbor in. So I think, broadly speaking, similar messages that we've discussed today, and a lot of it will be around implementation. I would say the UK is perhaps in a slightly better position when it comes to implementation through regulators and regulatory capacity. The Information Commissioner's Office has always been one of the most active regulators and well-resourced, and I mean the two are absolutely
That's what
linked.
I was going to ask.
Yeah.
Why is it well-resourced though? Why did they choose to resource this from the start?
Oh, that's a really good question. I'm not sure I could speak to that. I think there's probably some historical and cultural investment in freedom of information in the UK and kind of open access to information that the UK really does hold itself out as a leader in open government and access to information for a really long time. And the ICO has, you know, is one of the largest in number and well-resourced regulators in the UK. But it should also be pointed out that there are other regulators here that have capacity that they're really bringing to the table and expertise, not least is the Competition and Markets Authority, which is arguably even ahead of the ICO in the UK when it comes to thinking about audit of platforms, because they're thinking about it in the context of pricing algorithms, competition, and of course, in the UK context, the regulator that will be charged with implementation of online safety is neither of those two regulators, but is Ofcom, which is the media and communications regulator. But what we're seeing is really interesting collaboration between the three of those regulators under the auspices of something called the Digital Market Unit, which has been established to encourage collaboration. I also think that there's a lot to learn from the financial sector's regulation in the UK, and of course the UK being the biggest financial services market and having done a lot in the way of financial services regulatory reform since 2008. I think there's probably some lessons to be learned there as well. So I think from a kind of implementation perspective, there's a lot of real opportunity here to develop some best practices, and hopefully there'll be some connections in with regulators on the continent as that happens.
Thank you. I think it's interesting that collaboration between different regulators is seen as necessary or possible now, and that disinformation is not separate from competition law to a large degree now anymore either. We have two more questions. Thank you, Carly. Two more questions here. We're coming 9 minutes left. So if you have questions, please send them right now. Claudia Pretner, she is the legal policy advisor at Amnesty International. Claudia asks, coming back to the topic of advertising, Owen, you want to take this one? Do the speakers think targeted advertising needs to be regulated more strictly as called for by the European Parliament and the EDPS? And could this help mitigate some of the risks? Owen.
Yeah, on this one, I think it's, so this is like definitely a topic which has grown in a lot of attention the last couple of months and year. And I think it's interesting because it speaks to a lot of concern you see in the European Parliament that it's some of the problems we're seeing in the online space are a result of ad-driven business models. And so the idea is that, for instance, the business models have a commercial incentive to promote content which can be inflammatory, which can be polarizing, and which can be otherwise objectionable. And so I think the DSA, like, as it's currently drafted, is going to address quite a few of those things if it's implemented properly. In terms of, like, there is a lot of language in there about looking at how content moderation, content recommender systems are defined, and looking at how advertising is served. So I think that the DSA is already looking closely at this. There's probably ways it could go in other directions. I think what will be interesting is seeing to what extent many of the problems which people are talking about in the online advertising space are going to be solved, or would be solved, by just a better enforcement and implementation of things like the GDPR. Because at the moment, like, going back to what was said earlier, there's a lot of pieces of that law which haven't been tried out very well. But I think that, like, I expect this conversation around the role of advertising and whether and to what extent it can and should be banned or mitigated will probably get even more prominent in the debate. So we have to kind of
Thank you, Ben.
So this one of the parties groups in the parliament just introduced a new campaign to ban personalized ads, and that's an idea kicking around in amongst different organizations in Washington as well. And I think the spirit of the idea is an appealing one, that if we prohibit the targeting of ads, that this might lead to disincentivizing profiling and the curation of content in ways that separates one group from another, or the public from facts, or many other negative externalities of customized content curation. But I think it is a misunderstanding of how the ad industry works. And I think it's a simplification, that you can define a class of advertising practices that are prohibited and they will be easily evaded. There are 100 different ways to customize and target an ad. And I think what we ought to be talking about is the root of the problem, which is the profiling in the first place. If you want to get at the problem of targeted curation, either in paid or organic content, why not talk about the collection and use of data in the ways that permits this, rather than trying to get at it through the practice of targeted ads? Which brings me back to the GDPR being something someone should really try, because in my view, this is already prohibited under the law. We just haven't addressed this directly through the GDPR. And well, I think it is reasonable to use a discussion about targeted advertising, behavioral advertising, to open this debate. I don't think we should fool ourselves that we can fix it by strengthening regulations on a particular type of ad.
Thank you. Carly, we've talked a lot about government, about regulators. What role does the public have in terms of regulating platforms in this way?
That's a great question. I think we're starting to understand the need for public consultation and public involvement in the development of real accountability mechanisms around large platforms. What I would like to see more of is more participatory approaches, where we really bring in members of the public to first do that kind of values definition piece that you spoke about, Brian. What exactly are the values? How, as societies, do we want to balance and trade them off? And secondly, to involve the public in these types of developing interventions in a necessary space. There's a lot of lip service paid to, for example, people don't care about privacy because they still use Facebook, and really digging into to what extent do people feel agency and choice in the online domain, and how would they design a system differently, I think could really be quite fruitful in trying to develop better, approaches to, for example, the use of personal data in the way that Ben described. And to rebalancing the power. I think most people feel so powerless in the face of the online platforms, and they can't imagine different futures at the moment beyond ones in which they have to use Google and Facebook. But as the recent developments in Australia have shown us, it may be something that we need to confront sooner rather than later. So trying to bring as wide an array of people into that conversation as possible, I think, is really important, and not least because the Silicon Valley mindset has dictated the way these platforms have been built, and now, as to Ben's point earlier, they are everywhere and they are being embedded in different cultural ways in different societies. So starting to really understand what that means, I think, should be a priority for us, actually.
Thank you. Owen, you want to follow on that?
I saw there's a question in the Q&A from Gabrielle from Article 19, which is, I think it's really interesting. I think that it's something that hasn't come up yet, is the idea of the interference with fundamental rights of the risk assessment process, and how governments in potentially undemocratic countries might lean on actors to suppress undesirable or politically sensitive speech. And I think this is going to be a challenge that we can address to some extent in the law, but it's going to require that constant monitoring, and it's going to require a lot of, again, this kind of polycentric oversight of the regulatory system. I think in any case, we shouldn't be thinking purely about content. So we shouldn't be thinking about what is the risk of disinformation, what is the risk of hate speech on your platform, but rather thinking more in the sense of operations. So really embedding the risk assessment piece into when a company is thinking how it's going to roll out a product, what markets it's going to deploy that product in, what kind of trust and safety functions it's going to have embedded into the product rollout to mitigate the many and manifold risks that may pop up. So I think that in the first instance, we shouldn't limit ourselves to like categorizing specific risks. Rather, we should make sure it's fluid and it's a constantly iterative process. And I think in that regard, the tech sector probably has a bit of an advantage, because one of the reasons that's made tech so successful is a philosophy of constant user testing, constant monitoring, and iterative feedback in product design. And that is at the core of risk management too. So I think that if we take that philosophy of how we build and implement our products towards how we assess and mitigate the risks, then I think the DSA will probably be a good step forward without some of the negative fundamental rights potentials.
I was going to ask you for a final comment, but I think that'll serve as your final comment. And we're 1 minute to go. Thank you, Owen. And Carly and Ben, just a 30-second wrap up. And just before you do, we have a comment from Colin Mashiel. Thank you for this fruitful discussion, excellent insight, and key regulatory policy issues raised. You're very welcome. Adeline Comboy, sorry we didn't get your question on the Irish safety media bill. We'll follow up on that afterwards. And to Laura Bartley also, we'll try and get your response just after as well. Thank you to all those who sent in their questions. Wrap up remark, Carly, Ben. Carly first.
I don't think I have anything particularly to say, other than I appreciate this conversation being convened, and it's great to see the opportunity to kind of delve into the details of this, and I hope there'll be more of them. Thank you. Ben, last word.
I want to end on a positive note and say, as this conversation has made clear, this is going to be a messy debate over the months ahead, even though I think there's strong support for the DSA in the Parliament, strong support for the DSA in the Council. There's an overriding momentum for these kinds of rules, not just in the EU, but in other democratic countries. How to do it, and in order to be maximally effective, will continue to be a challenge. But I think we have to keep our eye on the prize. Like, just the fact that this law has been proposed, that we're having these debates, that we're trying to figure out how to get at these problems through different mechanisms, will begin to change the industry. And that's a really important step in the right direction, and we need to carry on down this path.
Okay. Thank you, Ben. It's froze there for a second again as well. Carly Kynes, Ben Scott, and Owen Bennett, thank you so much for your participation today. Thanks to all our audience as well for your questions and your attention. And join us for the next Mozilla Morning coming soon. I wish you a good afternoon.